thank you to all of our attendees for joining us today. Today is a committee day down here at the Capitol. So committees are currently hearing bills, they're considering bills. And so we want to be diligent to equip you all with the information you need to assist us in moving really, really good legislation, as well as stopping very bad and very harmful and punitive legislation. So with that, I introduce our panelists today, some of the most amazing and really devoted experts in the field of justice that we have in this state. Start with Coco from Deep Center, and from the Georgia Justice Project, and Mazie Lynn from the Georgia Association of Criminal Defense Lawyers. I'll allow each of you to make a brief introduction. So first, I'll start with you, Coco.
Hey y'all, I'm Coco Guthrie-Papy. I'm with Deep Center based in Savannah, Georgia, and excited to be here today.
I'm Colloton. I'm the Policy and Outreach Coordinator at the Georgia Justice Project. So I am filling in last minute for Wade Askew, our Policy Director, who is frantically working on our bills. So I hopefully will be an adequate substitute today.
Hi, I'm Mazie Guertin. I'm the Executive Director at the Georgia Association of Criminal Defense Lawyers and also their policy advocate.
Beautiful. Thank you all. And we are so grateful to have you, and you definitely will be a valuable add to this conversation. So we appreciate you as well for coming in place of Wade. Next slide. We'll begin really talking through some of the bills that have moved since crossover. Some of them have been heard in committee, whether subcommittee or full committee, and it's pending a final vote before being sent to the governor. So first we'll start with House Bill 909 as well as Senate Bill 157, and I'll turn that over to you, Ann.
All right, thanks, James. These two are bills that the Georgia Justice Project is working on this session with the legislators. So House Bill 909 is the First Offender Act Modernization Bill, which is the First Offender Act is a law that allows someone who has been charged with an offense, misdemeanor or a felony, to receive a different sort of sentence. And it's not considered a conviction unless the status gets revoked. And so it allows someone to then, at the end of their sentence, currently that can be restricted and sealed. And so it doesn't show up on background checks, right? That's the law. That's the promise. That's what everybody is told by the judges and the lawyers. This is what's going to happen when you get sentenced under the First Offender Act. The problem is that the original bill was written in 1968, and background checks, as you can imagine, have evolved a lot since then with the digital age where everything's online. We need to bring that law up to date so that, because very often people come to the Georgia Justice Project saying, I was sentenced under the First Offender Act, but now it's showing up with these background checks, and I was told it wouldn't be, and so then they get denied a lot of opportunities because of that. And so this law will help that by requiring the restriction and sealing of those cases at sentencing. It's already crossed over from the House to the Senate. There was an initial hearing in the Senate yesterday in the Senate Judiciary Committee where some judges raised a few concerns, not about the bill, but about how that would happen in practice in their jurisdictions with their computer systems. And so that's what Wade is doing now, is working on new language that will still accomplish the same goals for individuals who are sentenced under the First Offender Act, but will also address the concerns that some of the judges have. So in the handout that I think we put in the chat, there's a call to action there about phone calls that you can make and talking points. So please do that. It will definitely help. Senate Bill 157 relates to occupational licensing and expungement. So this actually crossed over from the Senate to the House last legislative session, 2023, and it has a hearing tomorrow in the House Judiciary and Non-Civil Committee. And it's a very long bill. It's like more than 90 pages, I believe. But the biggest part of the bill relates to occupational licensing. And those are good, high-paying career advancement jobs. So not just a job, but a career profession in a licensed industry. And so that makes up 25% of the highest demand jobs in the state require an occupational license. But every licensing board has their own process and considerations of how they look at criminal records. And so this will sort of make it a more fair playing field and make it a little more consistent across all the different boards. And so the biggest things that it will do, it will allow someone to apply for a predetermination process saying, if I want to pursue, I want to become a nurse or I want to become an accountant, will my background be a problem or not? And so now a lot of times they're told even by the technical colleges or they just think I don't know, I'm not going to spend X thousands of dollars and all this time investing in my education only to learn later when I'm done with school that I can't get licensed. So now a person, if this passes, would be able to apply and say, I want to do this. Can you give me an answer now if my background would be disqualifying or allow me to do that? So that's number one. And then it will also change what boards are allowed to consider with a background check. They won't be allowed to consider everything under the sun, which is what they typically are doing now, requiring someone to disclose everything, no matter how old, no matter how long ago, no matter if their record was expunged or pardoned, no matter if it's related to the job at hand. So this will narrow the kinds of offenses that the board can consider to things that are more recent and more relevant to the job at hand. And then it'll also enact some due process considerations so that right now, if you're denied, you don't know why or what you can do about it. And so you'll get an answer. This is why you've been denied. And then you have a chance to appeal that. So those are the big things that 157 will do for occupational licensing. It will also have some expungement provisions in it. The biggest things are it'll lift the cap on the number of misdemeanors that can be restricted and sealed, and it will streamline the restriction and sealing of felony offenses, felony convictions that have been pardoned. So we're excited about that. If you do make phone calls about that, again, all the information you need is in the link in the handout. We just ask that you emphasize the occupational licensing parts over the expungement parts because that's where the most momentum and interest is in the legislature.
And if you could also briefly touch on 926 as well. I know that's a bill that you all have been working on.
That is an improvement on a bill that we passed a couple of years ago, Senate Bill 10, that allowed someone to get their driver's license back when it was suspended for an FTA, just a failure to appear. So there are, I think it's 10,000 people who, is it 10,000? Anyway, way too many people lose their driver's license in Georgia. And the suspended driver's license is a huge poverty trap where you get your driver's license suspended, then you lose your job because you can't drive to your job because you don't have a license, or you drive anyways because you need to feed your family and support yourself, and so you drive anyways, and then you might get stopped for something, and you just get stuck in this cycle. So right now, it's actually 105,000 people who get their license suspended for missing traffic court, not because of dangerous driving, but because they missed traffic court. And so this bill will improve upon what was done a couple of years ago so that the first time somebody shows back up in traffic court, either call to reschedule or to show up to the clerk's office to reschedule, they will get their license reinstated immediately. And it will also reduce the reinstatement fee to $0 for someone who is low income. So the reinstatement fees are very expensive. And so those are two big provisions in this bill that will be a huge impact on low-income drivers. And I will say, I don't know what the version of the bill that is listed online, so don't be alarmed if it looks quite different from what will happen. So if you're interested in that bill, sign up for Action Alliance at Georgia Justice Project, and we will send out something with that information soon. I know that there are some amendments happening to the bill soon.
Perfect. Thank you so much. Mazie, I'll turn next to you. If you could share with us a few things on Senate Bill 533.
Sure thing. So Senate Bill 533 has been brought by Chairman Brian Strickland. He's the chairman of the Senate Judiciary Committee and is attuned to a significant problem within the criminal legal system right now, and that is an excessive backlog of people in need of competency evaluations and restoration services who cannot access them because of staffing shortages, bed space shortages, and as defense lawyers, this is a space that can be a little bit that we kind of hold in tension because we never want to see our clients decompensating and their physical and mental health deteriorating. At the same time, we're not rushing sometimes to see their cases prosecuted. But what we do need is everyone that is in our criminal legal systems to get all of the mental health care that they need. And in this case, this bill will address specifically that competency restoration piece, and it will give broad freedom for those types of services to be provided in alternative settings like jails and outpatient facilities. There are a couple of these jail-based competency restoration projects in force right now. One is in Fulton County, one is in Cobb County, and they have, anecdotally, as far as I've heard, been very successful. I mean, so I think the hope is that by expanding the locations, realizing that we don't need to have duplicative bed space for people in need of these services, that if the service can come to them and they can access it more quickly, then their health can be addressed. Like I said, there's that tension because that facilitates the criminal legal system processes to move forward. But at this time, we are supportive of this as a mechanism for getting care to people that need it faster than they're able to get it today.
All right, thank you, Mazie Lynn. And I'll take House Bill 1054. House Bill 1054 is a simple bill, and that is something we hear a lot of times down here at the Capitol, where 10, 12 pages is very simple. But this is truly a one-page simple bill that allows for an individual who is pulled over on the side of the road and is given a traffic citation to sign, can legally now refuse to sign it and not be threatened to be arrested, or not actually be arrested, rather. And it really reduces the interaction of conflict that often happens when a person who doesn't want to sign, a citation for whatever reason, doesn't have to be arrested and take up space at the jail. Taxpayers have to pay, to house them for no reason other than they refuse to sign a ticket. And it also allows for them to be before a judge, and they can't resolve their case, by just paying up a fine. They have to first appear. So that's a trade-off in the bill. But the bill passed Senate Judiciary yesterday evening, and it is being heard, or it will be considered in Rules Committee as soon as tomorrow. We don't know if it will be called, for a floor debate or not, but that's kind of where we are in the process on that bill. So the call to action there is to just call every member of the state Senate and call your specific senator and ask them for a favorable consideration of House Bill 1054. With that, we'll now go to House Bill 1184. I think Mazie Lynn, you have that one?
No, I'll admit I was hoping this might be that one that Ann could address, but I can just generally say that victim-centered programs are just such a meaningful way of resolving matters that are today we often see the carceral system relied on to solve, and brings an opportunity for a more holistic addressing of problems that happen between people in our communities. There have been times when this concept has been called restorative justice, or phrases similar to that. It's the same idea and concept, but this victim-centered approach and, frankly, languaging is really important to remember at this time in our, at this time, and the way that the atmospherics and political process account for language. So this victim-centered program idea has been put forward by the Georgia Justice Project. So I suspect Anne has even more that she could say about it, but that's a brief introduction.
I'll just put a link in the chat. So because we're not sure if that's going to be moving or not. So I'll put a link in the chat and people can sign up for action alerts if that bill is able to move forward. It did not cross over. So we're looking for other avenues.
Perfect. Next, we'll go to some of the more negative bills that need our action as well. First, I'll go to you, Coco, on Senate Bill 63.
Thanks, James. Yeah, so SB 63 is a little bit different from some of the other bills that we've featured on here. SB 63 is already at the governor's office. It has not been signed. So what needs to happen is the governor actually has to veto it. And so we can talk about action items that might support some advocacy driven towards the governor's office. But we'll start with the fact that bail just makes the justice system like a two-tier experience, right? If you can afford to make bail, you can leave jail. If you cannot, you stay in jail. There's been plenty of evidence and data and stories that show that over and over and over. And unfortunately, what this bill has done is a couple of things, right? So the first thing is it added about 30 plus mandated bail offenses. And some of those offenses include things like marijuana possession, failure to appear for traffic court, unlawful assembly. So there's these really concerning nonviolent misdemeanors that we know are very directly linked to homelessness or to poverty, to behavioral and mental health. And so there's that portion of it, right? There's also the portion of it where it now controls how often you can post bail as an organization or as a church or even as a business, right? So bail bonds or bail bond companies have something known as surety bonds, and this essentially allows them to operate as a bail bond agency, right? And so what this bill does is it now requires any sort of nonprofit business or church, any faith house really, to register for that, or you can only post bail about 3 times per year, right? So really sort of tweaking with the ability for communities to respond to people in jail who need help with bail posted. We know this is also like a direct reaction to the past few years where we have seen communities pushing for bail reform, where we have seen progress in Georgia, bipartisan progress for criminal justice reform. And this really is sort of, I would say, like reactive pushback to that. So I think the best thing that we can be asking folks to do right now, especially if you live in communities outside of Fulton or DeKalb or Chatham County, so thinking about Albany or Brunswick or North Georgia or Macon, so communities where there is more rural communities, it is calling the governor's office and asking to veto SB 63. And we definitely have some information and some scripts you can use in our little legislative toolkit that you'll have access towards the end for. And with that, I will pause and turn it back over to James.
Thank you, Coco. I'll take Senate Bill 517, and then Mazie, Lynn, you can take 465. So 517 is going to be heard, I believe, tomorrow in House Judiciary Non-Civil Committee. And that bill, what it does, it provides law enforcement with civil immunity and protection from criminal prosecution for justified and lawful uses of force. It is, in some estimation, a clarification of the current law. And you know, whenever we're talking about police immunity and granting blanket immunity, there's always, you know, room for concern. But I'll add that the current state of you know, holding law enforcement accountable in terms of, you know, deadly uses of force is something that continues to be of concern to us. And so we just want to caution everyone on that bill to ensure that we are not expanding, you know, who would be eligible for immunity, as opposed to simply really simply a clarification, as the sponsor has alluded to in his presentation. Mazie, Lynn, 465.
So Senate Bill 465 remains in the House Judiciary Non-Civil Committee. It passed out of the Hong subcommittee yesterday. And I am pleased to say that the version that came out of the subcommittee yesterday is greatly narrowed from the version that's available online right now to the public. Bills do not become publicly available with ease via the website until they're passed out of the full committee. So at this moment in time, we can't easily post a link to the most current language that's under consideration for Senate Bill 465, but I can tell you that they have narrowed the scope of the actors in the drug distribution system that they are aiming to punish with this new law. They are trying to fasten it so that they will punish people who manufacture or sell for money drugs that have fentanyl included in their compounding, no matter what the drug is said to be by the person who has manufactured it or sold it. In addition, it does maintain the lack of knowledge component that is currently in Senate Bill 465, which remains a concern for our organization because we typically do not prosecute people for behavior they don't intend to do. And in this case, not only does the person not have to intend to cause a death through the manufacture or sale of this particular substance of drug, but they also don't have to know, the state doesn't have to prove that the person knew that there was fentanyl in the substance. So that bill remains under consideration by that committee. At this point in time, our position on it remains, like you see on the slides, like even with these improvements, it's still not a good bill. And I want to raise up that one of the major concerns about the way the bill was originally filed, it included language like delivers and distributes, which most certainly captured people who are living in addiction, who routinely can get caught up in charges under this code section 161330 because of the way drugs are used and shared among people. What we also know, especially it was mentioned in testimony yesterday by a nurse who works in the addiction context with people, that it is also not rare for someone who has drugs to sell a small portion of it to even to a friend. So this monetary exchange makes that a sale. And so that person would still be implicated under Senate Bill 465, even if it's just sort of part of the survival mechanism of the addictive process for them. So we still have grave concerns about the breadth of this bill, especially when you consider the fact that the sentencing scheme is a 10 to 30 or life sentence. You know, I feel like I'd be remiss if I didn't say it. By no means is GACDL's or anyone else's opposition to this bill meant to in any way, shape, or form diminish the tragic losses that are happening in our state and around our country because drugs are being tainted with fentanyl and people are unwittingly taking them and dying. I mean, it is an epidemic, but as I mentioned in the committee yesterday, and as I will continue to say as I talk about this bill, addressing addiction, addressing access to things like fentanyl testing strips, addressing the medical side of this problem, looking at ways to dry up demand by helping save lives on the front end, not through carceral measures on the back end, would be a much more productive and effective use of our government's money. For instance, a fentanyl test strip costs about $1 retail versus a day in a Georgia prison, which is upwards of $45. So those talking points I don't believe are included in the documents we're sharing with you, but feel free to use them as you reach out to your individual House members to say vote no on Senate Bill 465 and the members of Judiciary Non-Civil as well. Thanks.
Thank you, Mazie Lynn. And we'll just briefly go through the bills that we've worked on this session that did not unfortunately make it to crossover day. I'll actually go out of order. Coco, if you would mind, kind of give us a read on Senate Bill 179, and then I'll take 1214 and 1014.
So SB 179, essentially, it is simple, right? This is ending felony disenfranchisement in the state of Georgia. So what's important to note, ultimately, this is a rights restoration bill. So what we're looking for is we're looking for the Georgia legislature to allow folks who have had their rights taken away due to incarceration, essentially restore the right to vote, right? We have people who return home after being incarcerated and they pay taxes, they participate in civic life, they are community members in every way, shape, and form, except the fact that they do not have the right to vote, right? And so SB 179 simply restores the automatic right to vote upon leaving. So
thank you, Coco. In 1214 and 1014, 1214, the intent, what's filed currently in that online is a bill that would not eliminate juvenile life in prison without parole, but the intent, and there has been some work behind the scenes to get, language that says we want to just simply get rid of the sentence of life in prison without parole for any person who's under the age of 18. There is talks of possibly having study committee done for the summer. I don't believe any work has been done on that front, but we do intend for there to be continuing conversations before the next legislative session with a lot of the partners that are here today. And so if anyone is interested in having or being a part of that conversation of juvenile life in prison without parole, please reach out to us. House Bill 1014 is another bill that, though did not pass or get a vote in 2024, we're also committed to working GACDL, Southern Center, the Prosecuting Attorneys Council, Chairman Bill Werkheiser, the Georgia's for Alternatives to the Death Penalty, and others are committed to working in the I don't want to say aftermath as if the session has done damage, but after the session is over and has adjourned sine die, we're going to be working and having conversations with those various parties to ensure that we're all on the same page. So when a bill is reintroduced next year, we're all on the same page. We know what to expect in terms of the impact it'll have on procedure and to ensure that everybody is aligned. We may not necessarily agree on every single part of the bill, but we want to get to a place where there can be consensus, at least from a professional standpoint, to ensure that we all know what we're getting ourselves into. And so with that, we'll turn it to, I don't think we really need to go through the negative bills that are that did not make it. But what I will say again, and we cannot stress it enough, is that even though a bill may have died before crossover day, we are starting to see bills take shape and form in other vehicles. And so that's why it's very difficult sometimes to say, well, this is one bill's number, this is another bill's number, because they change pretty drastically. Like just today, we had a bill that talked about expanding the arrest powers for jailers. And in that bill, there was another bill that did not necessarily, move the way it should have, according to the author. And so that was placed into this bill. And so we're starting to see a lot more of that. And so just, as we are reporting out and we're sharing our updates, I know several of our organizations do that on a regular basis. Please feel free to reach out to us, to communicate with us, get on our listservs and subscribe so that you're getting the most timely updates. Because again, oftentimes the website is not the most accurate in terms of, what is happening in real time. And so we're trying to make sure we do our due diligence in communicating what's happening to you all. And so the feedback will be much appreciated. The QR code you see on your screen, if you have a question about your elected officials, like we're in the midst of now an election season, and there's a lot of lawmakers who are returning and running for re-election. There are some who are not, and there are candidates who will be running to replace them. And so to know who your legislator is, to communicate with them your ideas and your feelings on pending legislation and potential legislation for next session, know who your legislator is. And then if you want to call committees and talk to legislators about specific bills, the QR code in the middle is the information you need to contact them. And then finally, for individuals who are interested in where your rights are in terms of voting, whether you are formerly incarcerated or impacted by the system, or you simply just want to know what your rights are in terms of voting, you can get the information there on the third and final QR code on the screen. Next slide. I think that's it. Okay, that's it. So I want to pause there and see if we have any questions from members of the audience. I do know that many of our panelists, we have several committees that we got to get to, so we want to provide maybe like 5 or so minutes for some questions. And I do see 2 questions that we just received. Is there an update on House Bill 1283? I don't remember what 1283 is off the top of my head. Mazie, Lynn, I see you, so I'm going to let you turn that one.
So House Bill 1283 is the bill that modifies the definition for aggravated assault within the juvenile code. And yes, there is an update on 1283. The author has asked for that bill to be heard by the Senate Judiciary Committee. And we talked about this briefly at Justice Day. 1283 has been advertised by its proponents as a mechanism for using SB 440 to prosecute children as adults in every sort of aggravated assault case. What I can tell you is that when I read the bill and when the experts at the Barton Law Center at Emory, Child and Policy Law Center, I always get the name wrong, when they reviewed the bill, we don't see that. Even though that is the talking point around the bill, we don't see that in the language of the bill. What it clearly does is clarify the definition of aggravated assault within a designated A felony in juvenile court. I mean, no one would be sad if this bill didn't pass. I mean, it's in many ways not necessary, but it does not appear to us to be doing the harm that it's being advertised as trying to do. So I will just say at this point, our organization is just staying quiet about this bill because we feel like the more attention brought to it, the more chances are it will get amended in a way that it doesn't get vetted properly and actually do the harm that they are talking about trying to do. Because this says, someone else asked in the questions, like, this is the time of year when zombie bills and vehicles are starting to happen behind closed doors in ways that we have no way of touching. And so I certainly can't tell everyone here what to do about it, but as an organization, GACDL is just going to stand down on that bill unless and until we see it show up somewhere, and then we'll do our best to try to educate the individual members about what we see in it versus what the talking points are about it.
Thank you, Mazie, Lynn. And another question we have from Leslie, are there any sneaky bills or zombie bills or language we are concerned about? I know not necessarily at Southern Center, but just in the advocacy community in general, one of the things that we are really kind of trying to track, and I wish our friends at Southern Poverty Law Center were here, but we are really tracking this immigration conversation and what it'll look like in response to the murder of Lake and Hope Riley. Legislators have been, dead set on doing something to respond to it. We saw Jesse Petrie, he had a bill that passed before crossover. There was another bill, House Bill 310, I believe it was, that also passed Senate Public Safety 301. Okay, see, I told you I'm not good with numbers, but House Bill 301 was substituted in public safety earlier last week. And what happened was when we got word that there was something coming, but we didn't have the actual language, and the hearing was held. We still hadn't had any opportunity to see what was in the bill. And unfortunately, after the bill passed, again, without any public insight into what was actually in the bill, we finally got an opportunity to see what was in it once the hearing was held and the vote was had. And the unfortunate part is we don't believe that that is the only bill that'll be used in this way to respond in some way, shape, or form to the immigration issue at large. And so we're continuing to monitor that. And for more specific information and advocacy strategies, we would encourage you to reach out to Isabel over at the Southern Poverty Law Center, their policy director there, to really figure out what more can be done on that front. So I just wanted to also mention that in their absence. All right, thank you, Leslie, and the other question from the floor. Do we have any more questions? If not, okay, I see you answered that one too. Yeah. All right, do we have any other questions? Going once, going twice. All right, well, thank y'all so very much for your continued advocacy and support of the work that's being done here at the Capitol. And we are grateful for the work that you all do, not at the Capitol, because it is truly a mutual relationship. And we cannot stress enough how invaluable y'all's input is and your advocacy efforts. So again, on behalf of the entire panel, we thank you. We encourage you to continue to do the work that you do and serve the communities that you serve. And if we can ever be of assistance, I think I can speak on behalf of all of us. Please don't hesitate to reach out to us, and we'd be happy to help. With that, I'll turn it back over to you, Nikki, and good luck.
Thank you, James. Thank you, Mazie, Lynn, Coco, and thank you so much. I know I'm putting in the chat our website, how everybody continue to stay engaged. Although this is our final Talk Justice Tuesday event of this year, of course, the work doesn't stop. So I put in the chat our website to our coalition and how everybody can stay engaged in the work that we do. This is an effort that takes all of us. So, this is the end of this series, but not the end of the work. So again, our panelists are going back into committee hearings. We have, 2.5 more weeks before session ends. So busy day. So we are going to conclude for today, but please stay engaged into our website of how you want to be a partner. Our partnership is growing. Those of you, I've seen the names. Some of you have stayed through all 5 sessions. Thank you so much. But if you want to be more involved into the partnership ongoing and being a partner, reach out to me on our website and we can get you involved more ongoing. So again, thank you so much. Again, Coco, James, and stepping in for Wade and everybody. So I just thank you so much for being a part of this for us. So say goodbye.